As many eyes that have been on the Supreme Court this week, there were probably more back in late 2000 when the presidential election hung in limbo for more than a month. Between the butterfly ballots, hanging chads, and uncounted votes, Florida understands the meaning of disenfranchised voters as well as any state in the nation. Until the Supreme Court intervened in that case on December 12th, the Florida Supreme Court was the court of authority, and my guest today was the Chief Justice of that court at the time. Now retired and back in private practice, Charley Wells has written about those excruciating 36 days in a new book titled Inside Bush v. Gore. He says that day started just like any other, and he had no idea what was about to land on his desk.
No, I thought I voted early that morning and headed down to the Florida Supreme Court, believing that my participation in the 2000 presidential election was over.
How long had you been Chief Justice at that point?
I had rotated into the position of being Chief Justice in July of 2000, and so I'd been on the court since 1994, but the chief position rotates among the members of the court, and I had rotated into the chief's office in July.
You had been appointed by Governor Lawton Chiles?
I had. Governor Chiles, Walking Lawton, as he was known.
A Democrat?
That's correct.
You were a registered Democrat and had run for office once as a Democrat, but on the court, you were considered a conservative. Why is that?
Well, I think that in my evaluation of court issues, of issues that come before courts, that I did see matters from what generally commentators would view to be conservative. However, I had grown up in my adult life as a Democrat, and especially I felt strongly on civil rights issues as they had affected politics in Florida in the 1960s and 1970s, but on economic issues and general issues of government, I was probably more conservative than the other members of our court.
The final outcome of Bush v. Gore took 36 days. Seemed like forever at the time. What created that timeline?
That was a timeline that came out of the United States Code. And what we discovered, and it was something that had not been widely focused upon prior to this election, was that in order for a state's electoral vote to have a safe harbor as far as any contest when the Electoral College met, it had to have all of those controversies resolved 6 days prior to the meeting of the Electoral College. This meant that in the year 2000, the controversies, in order to ensure that Florida's electoral votes were not going to be contested further for casting votes in the Electoral College, that they had to be decided by December the 12th. Now, that was a date that, as it turned out, was agreed to both by the Gore lawyers and the Bush lawyers. It was a question that I asked at the very first oral argument. So that's where the 36 days came about.
Do you think the period should have been longer?
I do not. After my experience of going through the process, I think that it's very necessary for the country and really for the world, for the American presidency to be decided within a relatively finite, short period of time following an election, because a very essential part of our form of government and democracy is the peaceful passing of power in the presidency, in the executive branch of our government. And leaving long uncertainty as to how that's going to work, I think, is debilitating to the mechanism and the carrying out of the functions of the federal government.
By mid-afternoon, the day after the election, many were reporting that Bush was leading the election by about 1,700 votes. What did you think at that point?
Well, I thought, as you recall, the night of the election, there was a back and forth among the calls as to who had won the election. And I knew from the time that it was going back and forth, and they were telling us that the election was separated between Bush and Gore by less than 2,000 votes, that we were headed for some controversy. And so I thought, as I say in the book, is like what was reported that the astronauts in Apollo 13 said to Houston, we got a problem here. And so it was pretty evident by the afternoon of November the 8th that we had a problem.
What were the issues?
Well, the first thing that came to the top that I recall was the butterfly ballot. And there was a consternation in Palm Beach County, which is one of the three populous counties in southeast Florida, about the form of a ballot in which the supervisor of elections had attempted to make the ballot easier to vote, and in fact it had confused a lot of particularly senior citizens in areas of Palm Beach County who were saying that they had intended to vote for Vice President Gore, and when they had, in fact, because of the position of the names on the ballot, had cast a vote for Pat Buchanan, who was a third-party candidate. And so that was an indication that might very well become something that was going to have to be resolved by a court. And that was one of the issues. It was very soon after we got reports of, well, after the next day, really, that questions having to do with the other form of ballots used in Palm Beach, Broward, and Dade County, as well as 17 other counties in Florida, which were punch card ballots, and how those ballots were punched. And so issues were bubbling up from all over Florida, really within 48 hours after the election.
And then there was the overseas ballots, allegedly not due to the county office until 10 days after the election. Is that true?
That's exactly what happened next, as far as what I was hearing and then became concerned about, because it's very soon after the election and when the controversies began to arise, and I looked at the election statute, and then there were also announcements by Secretary of State Catherine Harris about the requirement that Florida statutes had put on having all of the ballots counted and reported to the Division of Elections in Tallahassee from each county in no more than 7 days following the election. But there was also an outlier in that there was information that there were a substantial number of overseas ballots, and that those ballots didn't have to be into the supervisors of elections for 10 days. So we had a confusing state of information that was reaching us as to the deadlines that we were looking forward to, had to examine in order to see when the ballot had to be reported to the Division of Elections in Tallahassee.
Part of your job is to interpret the law, but you found that not all of the rules were actually written in the statutes.
Well, that's precisely correct. And what was...
It's the Bob Edwards Show on Sirius XM Public Radio. Charley Wells was the Chief Justice of the Florida Supreme Court, where he served from 1994 until 2009. His new book is Inside Bush v. Gore. Wells had been appointed by a Democratic governor, yet was known to be a conservative on the bench. At the time, the Secretary of State in Florida was a Republican, Katherine Harris, and after several recounts had been made that year, she ordered them to stop. A state circuit court upheld that ruling, but the state Supreme Court, led by my guest, Charley Wells, overturned Harris's order.
What happened was that we concluded that there was the provisions in the statute had to be construed in a way to give her discretion, so that if there was a good reason shown, that the time could be extended. And we felt like that the record before us demonstrated that there was a need to have an extension of time. See, what you find, and I outline it in the book that I've written, is that we had statutes which had been written at different times by the Florida legislature, but were back to back, in which the statute the one provision said that if they're not in Tallahassee, the Secretary of State shall ignore those counties' votes if they're not there in 7 days. The next provision said if they're not there in 7 days, the Secretary of State may ignore the county's votes. Well, our judgment was that we're under the circumstances, and in making an attempt to have as broad a right of suffrage as we believe the Florida Constitution guaranteed all Floridians, that there was discretion on her part, and that she'd abused the discretion by not extending the time to allow there to be manual recounts at least for a couple more days. Now, there was also a reason that you couldn't extend it very long, because that was only part of what the statutory procedures were for after the election in Florida, and there was an entirely other way that elections were to be contested, and that couldn't start until after the protest phase had ended.
If the U.S. Supreme Court had not stepped in on December 12th, what would have happened?
Well, I felt like at that point that the United States Supreme Court needed to step in. In fact, I wrote a dissent in the second case that we had, which essentially was crying out for them to come in, because I thought that we had reached a point by really December the 8th at which it had become apparent that any further litigation and any further counting was not going to give us any more accurate result in an election which was essentially a tie than we had. And so I think if the United States Supreme Court had not stepped in at that point in time, that the controversy could well have gone on for several more months, because there was going to be controversy, and there was going to have to be a decision as to whether Florida's electoral votes were those that were represented by the counting or the recounting of ballots, or those that were or a delegation which was in the process of being selected by the Florida legislature. And so we were headed toward a period of uncertainty which was going to last a number of months. votes.
A great many people believe that the 2000 election was not legitimate, that Mr. Bush attained the presidency by a 5-4 vote of the Supreme Court. What do you say to those people?
I do not agree with that. I think that it was an election that was, as it turned out, the votes were cast in a situation in which the election laws, and that was the Florida election laws, didn't stand the test, the stress test of the fact that this election was essentially a tie, but that what came out of it was an attempt to have and the best attempt that could be developed to have a legitimate count of the vote. And we got down to a point in time in which what was necessary was a decision. And at the point in time that it became necessary that there be a decision, that Governor Bush had more votes that had been counted. And so that's the way that the election had to end. I think really the positive aspect to come out of the 2000 election, and I know that there's a lot of derisive things that have been said and felt about what happened in Florida in 2000. But the thing that was a positive that came out of that, and I hope would still be true today, and that is that everyone recognized, and I think our country relied upon the fact that once the final court, and in the end that had to be the United States Supreme Court because it was the presidency of the United States, but once that decision was made by the final court, that power was going to pass. And I think we had a consensus in the country that we were going to rely upon a decision of the court in the end, and it was going to be decided by law, by the court of law, and not in the streets. And I think that is a positive lesson that came out of the 2000 election that we will abide by, even in an election that is as razor close as that was, the final decision about the law that's made by the highest court in the land.
You've had 12 and a half years to reflect on Bush v. Gore. Anything that you wished you had done differently?
Well, I wish that our court had been able to come together, but I think at the end, but really my reflection is that it needs to be an educational experience, and I hope that the historians and teachers and law students will all focus upon what happened in the Florida election and try to develop election laws that will withstand the stress test of such tight elections, because now we know, and we're going through a period right now in which the country is very divided, and we're very likely to have very close elections. And so I really wrote this book for the purpose of giving my perspective on what happened, but with the hope that it will be somewhat of a teaching moment for legislators and for those people who are going to be decision makers on how to run elections.
What do you do now?
Well, I've gone back to practicing law with the law firm of Gray Robinson in Orlando, and I mainly spend my time consulting with lawyers. Florida has a mandatory retirement for judges, and I hit the mandatory retirement age, or as they say, I became constitutionally senile in March of 2009, and so I am back in Orlando now because we lived in Tallahassee. That's where the Florida Supreme Court is. So I'm back in Orlando and going back to the law practice.
Do you miss being on the bench?
Well, I do, and but I was on the court for almost 15 years, and I feel like that was a long enough period of time for me, and really I think that's a long enough period of time for just about anybody to be on a court of last resort. As I say, though it affected me, and I missed the challenges of being on the court, I believe in mandatory retirement for Supreme Court justices on courts of last resort and for football coaches.
But that's not how we do it with the U.S. Supreme Court.
No, and it's not, and it's never been the tradition of the United States Supreme Court. And there have been people who have served on the United States Supreme Court, going back to John Marshall, Chief Justice Marshall, who served for over 30 years. And and there are people, Justice Stevens, who are very fit and able people. But it's, to me, I think those court of last resort needs to have some degree of turnover so that the political appointment system can impact who is on the court. And because the courts make decisions on a sort of a stream of reasoning, and it becomes, I think, it is a fertilizer for a court of last resort, and very helpful to its growth for there to be turnover on the court. Not too rapid, but I think, as I say, that after a set period of time, it's good to have that turnover.
What do you think of the Roberts Court?
Well, I have a great deal of respect for John Roberts, and I think that he has done a very good job as being chief. I think that, as I often say about people say about my decisions, I agree with them when they're right, and I disagree with them when they're wrong. And I think it's just hard to pigeonhole that court in many ways. But since I am generally conservative in looking at views, I generally respect the work that John Roberts has done.
Do you all fix those ballots in Florida, or can we have a repeat of Bush v. Gore?
No, I think that the statutes have been amended so that there will not be a repeat, but until we have a stress test and have another election that is very, very close, we're not going to know. But the ballots, the form of the ballots have been changed, and I think that was as much of a problem as anything. Plus, the reporting requirements are changed.
Conservatives have been trying to tighten voter ID laws and make voting more difficult. They say there's too much voter fraud out there. Are their concerns legitimate enough to outweigh the infringement on voter rights?
Well, I think it's a balancing act, and I do think that in a part of the protection of the elections and the electoral system is to be able to identify people so that they haven't cast votes over and over and there aren't any fraudulent votes. But as to whether that's necessary or not necessary, I really don't have an opinion.
Were you embarrassed for Florida? I mean, there were people that felt that election made us look like a banana republic. And Jimmy Carter, whose people certify elections all over the world, said that the 2000 American election didn't live up to the Carter Center's standards. He wouldn't have certified it.
Well, I was not. I don't agree with that. I think that it, as I have said earlier, it was an election which was too close to call from beginning to end. And when you have that type of an election, you're going to have a lot of people who feel like that the election wasn't properly run or there was not proper counts. But in the end, I think that the process worked its way through, and that's the way that this has to be looked at. And I've heard all the criticism, and I certainly understand there being the outside the criticism from all points of view. But in the end, it has to be looked at as a process. And the process that we were trying to deal with was to come to a resolution in a situation in which we found that there were faulty parts of the Florida election process. There was a faulty ballot and faulty statutes. And so that, I agree with the commentators that say that was a mess. But that was not something that rose to the level of it being a fraudulent process. It just wasn't. There was no indication that there was fraud. There were just mistakes that had been made prior to the casting of the ballots that came home to roost.
Thank you very much.
Thank you.
Charley Wells was the Chief Justice of the Florida Supreme Court and author of Inside Bush v. Gore.